call to order this meeting. Well, have a motion, first of all, to come out of recess.
Move to come out of recess.
Second.
Been properly moved and seconded to come out of recess. We're here for the second public hearing. Please pay attention. We will open the public hearing, and we will first hear from Rich Wood, basically presenting the report. After that, it will be those who choose to speak in support of this request. After they have spoken, it will be those who are opposed to this request. And then there can be a rebuttal by Mr. Wood to those who are opposed. After that, commissioners can ask a direct question of any individual, but this is not a debate. So there is no speaking unless a question is directed to an individual at that time at the end of the meeting. You'll be given 3 minutes to speak. I have a timer here. When I hold up my finger, that means you have 1 minute left. So I don't think there should be any other questions on that, so we'll begin, first of all, with Mr. Wood. Thank you.
Seems like deja vu.
Yeah, good evening.
Good evening.
Several years ago, this body, the County Commission, asked that the Planning Commission prepare subdivision regulations. Now, this is a process that sort of repeated itself since the 1960s. The outcome of that was a preparing of a draft document. The indication from the commission was this is more than we want, try and make it less. And every intervening step until we get to this draft has been to try and bring it down to the absolute minimum that meets the state requirements. We have received several written comments and some call-ins. We provided that information to the county clerk for the record. And if you have any questions at this time, I'll be happy to answer. Otherwise, we can proceed with the rest of the public hearing.
Thank you.
Okay, thank you. Now, it was a question earlier before we begin on those who support may I come and speak again. The answer is yes, but no more weight will be given to speaking again because you have been heard. Okay, so those who wish to speak, first of all, if we have somebody speaking in support, please come forward.
My name is Kyle Hawk. I am a member of the Planning Commission, and I act as the president. And I'd just like to thank the commission for hearing this today and for giving it a great thought and diligence. And I am obviously in favor of it. I voted for it out of the Planning Commission, and I'd ask you guys to approve it, but also to hear all sides and debate it fully. And we really appreciate you guys scheduling a hearing and talking about this. And it shows you guys are, as a commissioner, very supportive of the bodies you appoint, and we greatly appreciate it. So thank you.
Thank you.
Thank you.
Next.
Bill Kowecki. I'm Mayor of Morgantown. I was here this morning, obviously, and had my say, but wanted to just follow up a little bit with comments. Mainly this morning, I didn't hear many objections to this completely being out of the. Everybody wanted to see something happen. They may have had some objections with portions of this. Those, I think, can be addressed. I think this is way past due. I think the idea of planning in the county, I don't think there's anybody here who would think that we do too much planning, that we are too restrictive. Again, I suggest to you that the idea of unintended consequences are things that we have suffered from the lack of planning. That's affected our traffic, that's affected our sewage, that's affected our runoff, our MUB problems that we've had in various locations. All of this is due to just sort of a free-for-all kind of approach to what has been done in the past by developers who, good intentions, but they take care of what they need to take care of, period. And let whatever falls by the wayside be somebody else's problem. This is a movement to remedy those circumstances in this situation. I would advocate for this. I think this is a very small step forward, but it is a step forward. And I urge you, please, to take it on.
Thank you.
Thank you.
Thanks for the opportunity.
Next. Any others wishing to speak in favor? Okay, we'll begin with those who oppose. If you would step forward.
My name's Scott Copen. I'm with Cheat Road Engineering. I as well spoke this morning, but a couple items came up that I felt I just had to discuss this evening. One, there was a question about how people were relating this to affordable housing and the impact it would have on affordable housing, and it was kind of implied that that not adopting these would fix an affordable housing issue. That won't fix anything to do with affordable housing. That's the status quo. Is going to keep going the way it's going now. However, adopting this ordinance will affect affordable housing. It will negatively affect it because the requirements put forth in here they're not realistic for this county. They need to be tailored for this county so that the requirements that do go into effect, and I think most of us agree we do need something, just not this. There was some discussion this morning as well about, I guess this document's been around for, I think it was said 861 days. I don't remember hearing about it in the public, through the newspapers or radio or anything like that, with the exception of just prior to that. I was one of the engineers in this county, in this area, that was asked to help draft the original subdivision ordinance, and I did that. There were several of us that took part in that. My understanding is that information was given to the Planning Commission. They found it to either be too rigorous or they didn't like it or whatever, and it was tossed aside. That's disconcerting a little bit because it was written by the people in this county that understand this county and the constraints that we have to deal with. I don't think this takes that into account, and I think that we should slow down and let that group of people convene again. Whether I'm a part of it or not, we should leave it up to the people that know the constraints around here to work on this. Another issue that came up, and it kind of speaks to the ambiguity that several people spoke to this morning. There was some concern by people that this could create impact fees, and it was stated. I believe Commissioner Sikora said that impact fees aren't noted in this document. There is on page 3, item 1H, implies that the community will be required to bear no more than its fair share of the cost of providing the facilities and services required through requiring the developer to pay fees, furnish land, or establish mitigation measures to ensure the development provides its fair share of capital facilities needs generated by the development. That may not say impact fees, but that's surely what it implies. And if you go to page 7 of the definitions, definition number 48 is impact fee, and it defines impact fee. If impact fees aren't a part of this document, then why are they defined? And if they're not intended to be a part of this document, why are they defined? Further, I don't think the state law gives this commission without zoning ordinances the ability to even have impact fees, and it needs to be taken out.
Thank you.
Thank you.
Next.
Good evening. My name is Joe Panico. I'm on the Planning Commission also. I've been part of this document in the past. And I will tell you, this is not quite the document that I seen before it was sent up here. There's been many, many changes to this document. This document, the basis of it is saying that it's mandated by Law 8A of the state. This is literally the law. If you read the law, our goal has always been subdivision regulations and not land development regulation at this time. two different items that they're trying to cover both bases in this document. 111 pages of law dropped on this county to cover everything outside the municipality. There are literally hundreds of contradictions in here. There are numerous problems. I mean, I don't have 3 minutes, don't give me enough time to do it, and I'm just trying to glaze over it quickly. But the truth is, this is a subdivision ordinance that's really, it's a zoning in disguise per se. It's in 8A, it talks, you can have land development or minor subdivision, not and. We have included and in part of that, and we are dictating use. Use is zoning. This exceeds the definition of subdivision regulations tremendously. It oversteps the bounds of that. There's some good stuff in here. There are some good workable stuff that we have come up with and argued about that will work, but then they've taken it to a whole nother level. This law is poorly worded at best, and it's a disguise of zoning, and it's a total legal and logistical nightmare potentially for this county if it's just approved as is. This needs a lot of work. It could be done. It could be done with more work. Nobody's saying we're not afraid to work. There's a lot of people here that are saying, hey, we could work this out and make something that's relative to all, but this needs much more work for it to be usable in this county, in my opinion. It is disguised zoning as it stands right now and will cause the county nothing but problems and probably a lot of money in legal fees. But for 3 minutes, that's about what I can say, so thank you for your time.
Thank you.
My name is Leo Brewer, living in Morgantown, or Monongalia County. As he mentioned, we almost have prima facie evidence of undesirability of this given 111 pages. Think of our tax code and how it started out maybe small and has grown over the years. So this is just the beginning if you go with something like this. Another thing, I think one of the gentlemen mentioned the cost of housing. We already know, or should know, that housing in Morgantown is some of the highest in the state. And in fact, we're even higher in Pittsburgh, which people find hard to understand why a less developed, or a supposedly poor state has more expensive housing than Pittsburgh, Pennsylvania. These regulations will add to the cost of housing. There's no doubt about it. There's a listing of government fees there to be paid, but those are a tiny portion compared to the fees that will be paid for the document submission. Think of the professional engineers that are going to be required, draftsmen, not to mention lawyers who are probably slobbering to get this thing passed. Now, aside from the increased cost of housing, is importance to me the complete impossibility of providing housing options desired by many young buyers. For instance, many buyers, and I've had experience with this, young buyers would like a 1-acre parcel, and they want to have gardens, play areas for children. They park their boats and their campers and so forth. If these subdivision rules are implemented, those lots will virtually disappear, a 1-acre lot and available to these people. Because where you factor in paved roads, sidewalks, central sewage, and so forth, the cost of the lot will go beyond the ability of the young people. For instance, a local banker run numbers for me and some friends where basically they showed what would happen with the Ashton, the Sage, Harvard, Ridge, Morgan Point, and so forth. Those lots are sold for $40,000 to $60,000 per quarter acre. Now, at the same time, right now, a young couple can get 1 acre for $40,000 to $60,000 in some of the outlying areas. But the bankers told us that if we have to put in all this stuff that they do, we can't sell 1 acres anymore because it would cost 40,000 times 4 for the buyers. And so the people that have this land now that would sell to these people, they'll be forced to sell for, instead of 40 or 60,000 acre, they'll have to sell it off at 5,000 acre to a
Thank you.
developer.
Thank you.
Thank you very much.
Next.
Bill Burton. I'm a resident of the city of Morgantown, as well as this county. A couple things. One, I have a question on the stormwater management and the drainage. I was on the board of directors of MUB when we enacted that one, and we're in areas of the county because we supply water to them, and there would be a lot of problems if these two did not mesh, and we're not exactly the same, because then you're putting the residents on an undue burden of who do they deal with. Secondly, how does this zoning or planning document, you want to call it, impact the existing planning districts that we have in this county? We have several. Does this supersede them, or does this have to work in conjunction? And then all of a sudden, we have a county-wide planning district, then we have sub-districts underneath it. As addressed, the gentleman said about cost of housing, I'm a realtor. We do not have enough housing in this county right now, and we do not have planning, and we can't get it built because of the cost of land. If we put these in, you're going to see more restrictions. You'll see the Dan Ryans who are building tract areas of homes pull out of this county because they won't be able to afford to buy the land to build these homes. We can't keep up with the demand. Prices are going up because there is no houses being built and there's no houses for sale. And it's a real problem. And if this is not done properly, it's going to make that problem even worse. And the prices of housing will go even higher. And it makes it tough to employ people in this county when you can't provide adequate housing. We can't get industry to come here when executives of companies cannot find housing. That's one of the key things they look for: housing, schools, and amenities. And if we can't supply those, we won't have the employment in this county. Thank you.
Thank you. Next.
Good evening. Thank you for listening to the public. Since I only have 3 minutes, I'm going to read this pretty quickly. This ordinance is current.
name,
Oh,
sir?
I'm sorry.
Your name,
Chuck Lemley, landowner in Mon County, with knowledge of engineering and surveying, I guess. This ordinance, as currently constructed, is far more than a subdivision and lot split regulation. In the draft ordinance, the words commonly used land use regulation, as determined by the Planning Commission. In this sense, the ordinance is more like a zoning ordinance. In general, the whole ordinance is restrictive to private landowner rights, and as such, there will be winners and losers, and the county assessors should be adjusting land values to account for this. In some cases, land will be rendered usable only as hunting land and not suitable for lot splits or future housing. Tax assessment should reflect this devaluation of the property, while other land will be in locations where the topography can comply with these regulations and should be adjusted up in value. Enacted of the ordinance will have an unintended consequence of driving up the cost of future residential developments due to significant added cost in compliance with road construction requirements, bonding, as well as underground utilities, even in low-density subdivisions. In high-density subdivisions, curbs and gutters and sidewalks should appear to be and will be required, and apparently fire protection potentially for all subdivisions, which will require a 6-inch water line and acceptable flow rate. These added costs will be spread across the selling price of future subdivided lots. In addition, future subdivided lots will be reduced as many developments will not be economically feasible. The demand will be high for the few remaining lots, which will drive up prices. Middle-class citizens, teachers, nurses, and service industry employees will be priced out of the market. Developers will seek to relocate to more favorable areas to do business, like Preston and Marion counties, as well as Greene County, PA. Increasing property tax levels, which have been achieved because of the new homes being constructed within the county, will be reduced for fewer home starts in the future. Construction jobs will be negatively impacted. In general, this ordinance will do it as intended. It will control and direct growth, but it will greatly reduce future growth, and while reducing affordable housing and trespassing on individual property owners' rights. I assure you, as worded, the lot splits within this county will fall under major subdivisions because almost all of them require some public road or some road to be built off of a public road, which means that even a single lot split won't be exempt if it's not to a family member. So, and it won't, a minor subdivision only is good if you're along a public road. So essentially everything will be a major subdivision. Public hearings for major subdivisions, I'm concerned about that, because if you do comply with all these regulations, are you going to allow adjacent landowners who are opposed to your development shut the project down? You've done everything. You've paid $150,000 in engineering fees. You've complied with all this stuff. You put curbs, gutters, and bells and whistles, and your neighbor's pissed off because you are putting a subdivision beside him. Is that going to shut down the development? We need a stronger. Okay, sorry.
It's okay.
That's all I got for you. I have a lot more.
Well, you can still submit it to
You may
her
submit.
as a written comment.
I'll provide you with written comments to
That would be
specific
great.
That's fine.
regulations.
Thank you.
For time's constraints, that's why we have to limit 3 minutes. You understand? Okay. Next.
Hard to get through that.
Good evening, Mike Callan. I was here this morning. I'm not going to rehash the couple points that I made. I do have some written comments that I didn't have this morning that I'll give to you. But, I think when you listen to all these comments, I think one thing we're hearing is this is doable, but it's going to take a lot of work. I'm not a land developer. I am an attorney, and in my prior life I used to do property work, and I can see from that standpoint some of the issues. But they're engineers. You've got competent engineers in this county. You've got developers. You've got finance people. I really think you need to sit back. Otherwise, you have the capacity here to do a lot of damage. Affordable housing is a real problem here. The developers brought up some issues that I'm not familiar with, but they said, hey, 12% is not going to work. 2 sidewalks is not going to work. Glenn Adrian brought up an issue of financing and the bonding. You look around Morgantown, by the way, mention those 2 factors. I wonder how many streets in Morgantown would comply with these regulations. How many are within 12%? How many of them have 2 sidewalks? I've lived here all my life. I think Morgantown's pretty good, and we don't have 2 sidewalks on most of the roads. And we've got a lot of roads more than 12%, but somehow that figure was arbitrarily picked out of, I don't know how it came about. I think you need to get the experts, the engineers who have designed local subdivisions, the developers who developed, and financiers on a committee to work with your planner. Your planner's a planner, but I don't know him. I don't know if he's an engineer or he's done any engineering. You need to get people who have done actual projects in this county to rework this. Otherwise, you're going to make the affordable housing a lot worse. On the financing side, one point on that bond that I don't know that Glenn really explained it. He mentioned he had an $8 to $10 million project. If he had to get a 115% bond, he would have to get another $10 million or so. I'm not sure that he made it clear. He would have to get the financing for the $8 to $10 million. Then he would have to come up with $8 to $10 or $11 million in assets to back a bond. Because I can tell you, I do take care of bonds for regulated businesses. Insurance companies do not issue bonds for $10 million unless you've got $10 million of assets to back it up. And a bank will not issue a letter of credit for $10 million unless you got $10 million of assets to back it up. You add that $10 million on top of that $10 million, and what you're going to do, you're going to eliminate almost all the local developers. Only the Dan Rhines of the world, a few big developers will be available in this county, and the consumers are not going to have a choice. So there's some serious issues here you all need to address with the local experts. Thank you.
Thank you.
Next. You have to forgive me, I can't see behind the post there if somebody wishes to step forward.
Yes.
Good evening. Thanks, guys, for the opportunity. I'm Brian Gallagher. I'm a lawyer here in town. I've been blessed to represent developers for 20 years. And, I'm not really here on behalf of any client, but I tell you, in the last 2 days, I probably had 20 phone calls and the responses have been everything from, well, I'm just going to kind of pack up and move to Marion County, or I actually had one caller that said he was thought it was probably a good idea to wait this out because he thought he had the financial wherewithal to kind of withstand all this and would be the only player in town or would be able to get more of the market. And so those range of comments got me thinking, and I'm going to plow a lot of ground. I wasn't here this morning, so I'm probably going to replow a lot of ground of things you've already heard. But, those comments got me thinking about the unintended consequences of this. So I just kind of read the ordinance and and thought about some things. And, you know, I grew up on the other side of Blacksville, and my family's got a 130-acre farm out there. And I think when you read the statute, read the ordinance, if my dad wants to build a barn and extend a road to it, because it's a development of land that's kind of really not defined technically in the ordinance, that he probably invokes this ordinance. And he may get exempt and he may not, but he's got to come in and go through the process. And I don't know that farmers contemplate that. Same thing, I mean, this happens in western Indiana County. I mean, if my father wants to extend a road up the holler past his house and give 3 acres to someone and give 2 acres to someone else, you got to go through this process. And I don't know that that's what everyone contemplates by this ordinance. There's just some, we all know that gas interest is picking up in the western Indiana County. Same thing, if on my parents' property, someone wants to drill a well, I think that it's land development and we probably have to go through this process. And, you know, and I don't know that that type of development was ever contemplated or is really much of an issue. Wow. A couple other kind of big things, or just specific things in the ordinance. You know, we've got this hillside development concept where then anything that's over 10% slope invokes the ordinance. Well, if you look around town, I'm not sure that there's any sort of major retail development that would satisfy that. I mean, they're all over 10%. And so I don't think there's any of the developments that would be able to even qualify under that, those requirements. So I think we need to look really closely at that. You know, I don't know that anything would qualify for hillside development or would be able to meet those criteria. I don't know where, I mean, it seems like there's a whole lot of zoning concepts kind of woven through the ordinance. And so I think this was probably modeled after another county that maybe had a little more extensive zoning. And so I think we just run the risk, and there's going to be a lot of issues over whether or not this is zoning. So, all right. Thank you. I'll submit written comments.
Please. Next.
My name is Fred Friend, and I'm an excavator. And basically my job is digging new foundations for a couple local companies here in Morgantown, and that's about all I do. I'm also developing some property, and I'm in the middle of it now with first phase about halfway done, getting ready to get my paperwork in for my second phase. And I'm just wondering, you know, how this is going to affect my development when I have so much money spent in engineering and infrastructure already. When does this law go into effect, or, you know, is there a grandfather on it? You know, that's just the questions that I have, but basically it's going to put me out of work unless I drive to Marion County or PA every day. And I just would like for you to think it over. Thank you.
Thank you. Next.
Anyone else?
Seeing no one come forth, Mr. Wood, do you wish to rebut? Excuse me?
Can some of us give some additional comments?
No, this was stated in the beginning, okay?
Plenty of time, right?
If you wish to submit, then please do, okay?
Rich.
Oh,
We have
just,
someone else, I'm sorry.
oh,
I didn't see him.
Sorry, we're hidden behind the post.
We were comparing some notes there for a second.
Okay, all right.
Robert Schuman. I want to bring up just 2 points.
Okay.
And someone spoke about it before, about the contradictions or the inconsistencies with MUB's regulations. With this bonding concept for infrastructure of 150%, that's going to fly in the face of the concept with MUB, where you have to put up 100% in cash for their infrastructure with MUB. So you now have two inconsistent requirements for infrastructure under this ordinance. The other aspect of it is, and I think this gentleman brought it up, is if the costs of putting in developments or any subdivision are going to increase so substantially between the legal fees, the engineering fees, then what you've effectively done is decrease the values of these properties. So therefore, you're going to see an onslaught of people starting in January in Mark Music's office, and they're all going to be asking to have their properties reassessed to drive the values down, which is then in turn going to drive down your tax base. Because if I can't sell to Dan Ryan or to any other developer for what I could have, because their costs of development have gone up so substantially that my property is now worth less. So therefore, I need the assessor to reevaluate the value of my property, which is going to cause an onslaught in Mark's office of people looking for reevaluations to drive down their tax valuations. Thank you.
Thank you. Anyone else? Seeing no one come forth, Mr. Wood, would you care to rebut?
Well, I'll just make a couple of comments. Again, this document is based on 8A, the section of West Virginia Code that requires what is in a subdivision regulation. There are certainly areas where even as a planner or as a planning commission might prefer to do something else, but you do not have a legal document if it does not comply with the state enabling legislation. You also have to understand, yes, it's a rather lengthy document, but it also has to serve both as a planning document, as an legal document, and as an engineering document. And therefore, it is somewhat complicated and is more extensive than you might want. There's been several allusions to the fact that the subdivision and land development regulations are somehow zoning. Nowhere in this document does it say that any portion of the county can only have certain land uses in it. That is what zoning is. It was raised before it was submitted to this. We submitted it to the assistant prosecutor. He has issued a statement that no, it is not zoning. So I don't know where this whole idea of confusing subdivision regulations with zoning regulations are coming from. Zoning is a completely different process. There was a question about how does this work with the 4 planning districts. Again, zoning is different than subdivision regulations. These subdivision regulations, by that same state code, will be county-wide. It is not in addition, well, I suppose you could say it's in addition to the designation of the planning districts, and in the case of the West Run, in addition to the zoning ordinance, but that is all it does. It does subdivision regulations on a county-wide basis, and there's no choice on what geographical area the county can do that. I'll answer any questions as you get to the question.
Thank you. All right, at this point in time, commissioners may direct a question to those who spoke directly. They may answer if they choose to. Tom, do you have any direct question?
Again, Rich, if you could, Bill Burton brought up again about the planning districts, and you were talking about that. And I think I brought it up this morning. The question I have for you is, if the people voted for a planning district and didn't ask for a subdivision, how do we then tell them they wanted something, but we are doing something different? How is that? I'm a little confused. And his question was about legality, and I think that's a legitimate question.
Okay. The citizens did not vote for a planning district. They petitioned this body, the previous versions of this body, and this body created the planning districts. They voted in the case of Cheat Lake, Cheat Nick after there was zoning, and then it was petitioned to put it to a vote and voted it down. In West Run, they voted to have it passed. That's the only votes involved. Okay, and that, again, you're confusing various land use regulations. All's the designation does is designate a geographic area, which we have done comprehensive plans for, but of course, the comprehensive plan has no implementation associated with it, unless you have the underlying zoning or subdivision regulations or building and code inspection or something like that. Now, the subdivision regulations do not get voted on except for by this body. Again, this all goes back to the state statute. But it's not like what you're saying is that the people in the existing planning districts voted for the planning districts with the idea that they were setting up a planning district with no land use controls, and because the county is now having a county-wide land use control, somehow they're disenfranchised.
Okay.
Have you another question?
Yes, I do.
Okay.
How do you answer for those developers who may have already started on phase one of a development, but have maybe in written form phase 2, 3, and 4, then this is brought in and everything changes and the cost changes because they had spent the money based on what was set in place? How do we deal with that?
Okay. Under the ordinance, if the development has already been platted by the date that this ordinance goes into effect, not the date of adoption, but the date that it goes into effect, then it is essentially grandfathered in. So if you have additional phases, you need to get those platted.
But if they have the phase, but they have not actually gone through it, so they would not then be grandfathered in?
If it's not platted.
If it's not platted.
Okay,
If it's not
that's the answer.
platted, then those additional phases would have to comply with the ordinance.
Okay. And again, just for clarification, as you said, it's an all or none with 8A, and I want that clear. So
Again,
it's either
that
all.
You
We
cannot
understand that.
pick and
We're-
choose that you just
Well,
want
I'm
to
just
do
making-
roads
I'm-
or you just want to do subdivision regs.
Questions, please, Tom.
Okay.
Okay.
Yes. As of right now, could you explain what we could do since right now, is it not correct that the only alternative they have if the planning commission chooses against the decision, they go to court as it's written right now? What would be other options?
The other option is to create the Subdivision Board of Appeals, which is allowed under 8A and follows the same requirements as the Zoning Board of Appeals.
Okay. With these major changes, would we then need to change the individuals who are now put on that planning commission? Because some of them are just regular people who may not have the skills to deal with what the engineers and the others are talking about. Would we have to make a major change on that?
I don't think so. We have a developer, we have a contractor, we have an architect, we have 2 engineers, we have a retired person with a financial background. You know, we have a pretty good mix that's on there right now. And also, the county surveyor sits on there as an ex officio member. We have 2 lawyers. I don't know that you're going to get a much better mix than that.
Okay. 2 questions. One, the major concern that we keep hearing is our topography in Mon County, and how would you address this 10 or 12%, no more than 12%? You look at City Morgantown, Grand Street, or others. How would you develop that throughout the county?
Well, actually, Scott had given us, there was 2 points where it deals with grade. One is in the length of road in grade, and there's some standards that Scott provided that we could swap out there. There's some question that it could be increased more than 12%. Just for this, so you know, under most ordinances, subdivision ordinances, this is nationwide, obviously, not in the topography we have here, the cutoff is 6%. A few of them go up to 8%. So 12% is double what would be average. Now, again, that includes areas that do not have the topography of Morgantown. But you do run into a limit that you can't put subdivisions on the side of hills, and we've seen some of that in the county too. And gravity is a never-ending force.
Okay. Mr. Sikora, do you have questions?
Yeah, Rich, I'm going to ask a couple questions. I'm going to jump around different sections. I hope that your memory of it is enough where I can point the section out. Like section 2.9 under exclusions, there's only 2 examples there. I mean, there's only 2 instances there of exclusions. Are there not others, or could you provide examples of what an exclusion would be?
I am not familiar with what.
2.9's exclusions, the following actions do not constitute subdivisions or land developments or otherwise be subject to the requirements of this ordinance. And then it goes into talk about the sale or transfer of 1 or more parcels. That's A, and the second is granting of rights. That's it? Those are the only exclusions?
I really would like to read that section and give you your answer there. That is what it states, I have to assume that those are the only 2 exclusions.
Okay.
Okay.
Thank you, Patty. Oh. Yeah, as written, those are the only 2 exclusions.
Okay. And I go back to those 2 examples, so everything else is subject to the ordinance, and that's another thing that I think was mentioned, but I've kind of got that as I'm looking through this. You have exempts, you have minors, and you have majors, but anything that requires a road to it ends up being a major.
Except for the exempt. The exempt that we allow up to 5,
Okay.
that is not a requirement in that.
Okay.
So you can do that, and we have defined what constitutes a driveway. So the one example wanted to give some houses out there. The section on minor that requires that there can't be an extension of road or utilities, that is because that comes directly out of a section of 8A. We have no choice. If we had a choice, we would probably modify that and just allow developments up to 12.
Okay. In regards to when it's talking about giving land to family, dividing in family, special provisions for giving land to families, you guys go as far as to delineate what a family is?
Right. That section had been reworked. Originally, in the enabling legislation, it makes a provision for being able to exempt family splits. And that's what we started with, was an exemption for family splits. Over the course of working through this ordinance, we essentially did away with the family splits and just said anybody doing up to 5 splits are exempt. So you don't have to be related by blood, marriage, or anything like that. Anybody that's doing 5 splits or less, it's an exempt project. 6 to 12 becomes minor. At 12, that's also when the requirements of 36B kick in, which, among other things, requires the homeowners association.
Okay. And in regards to homeowners associations, so what's the difference between is there a difference between homeowners associations between minors and majors?
No.
It's basically the same thing.
Because if you're less than 12, you're not required to have a homeowners association under 34B, which is another separate. 34B is a section of West Virginia Code that addresses setting up homeowners association, defines the difference between condominiums and co-ops and that sort of thing.
Okay, so maybe I made an assumption then, but under the minor subdivisions, you still have to develop agreements for the care of the roads, correct?
It's advisable, but you're not required to under the law.
Okay, all right, I may have read that differently. I've heard it mentioned a couple times, the 4-foot sidewalks on both sides of the road. There's a reference to the state regs, but I don't see the 4-foot discussion. Where did that come from?
The I believe you do have, 4 foot is pretty much standard.
Both sides?
Well, both sides, people walk on both sides of the road, so yes, both sides. You also have to understand that that is in your higher density developments. It's not required in all of them. What is required, that there be at least an easement established, so if they wanted to at some point put sidewalks in, that's available, but it's not required there. But you're only talking about that in your higher density developments. But the minimum required, I think, is, no, I think it may be 40, it may be 4 feet, because you have to have it handicap accessible, so you have to be able to get a wheelchair on it. And I'm not sure 36 inches allows for a wheelchair.
It's 36 inches per ADA/IBC, but in most cases they jump up to the 4 feet, because if it's the 36 inches, it's just the wheelchair and nobody can get around it if they're going in the opposite direction on the same side.
All right, I appreciate it. I have a couple questions in regards to the bonding. Where did the 115% number come from?
I believe that probably was the number that was used in the Putnam County one.
Okay.
It was either that, or that was what was in the original draft that Director Kelly had.
Okay, so
utilized.
there is no, I heard a 150% number
No,
referenced there.
115 was, that's to assure that you have a cushion on that. But we're going to need to look at that, as I explained in the issue before. We want to make sure that that's workable. I think you also questioned about alternatives to a bond, and yes, under 8A, and I believe under our ordinance, but I'd have to reread that section, you do have options other than the bond. You can do the letter, irrevocable letter of credit, that kind of thing.
Yeah, there's some references in 8As to be able to use not limited to bonds, impact fees. Someone mentioned that you don't have, it's not legal to do impact fees. It's in 8A. But it says not limited to bonds, impact fees, escrow fees, and proffers. Okay. There was one section in, Patty, if you can point him to 7.2C. It talked about collecting bonds, letters of credits after the project had failed, and that seemed to contradict the earlier section. So there seemed to be a confusion. And for the record, I've provided these 3 pages of questions to the commission, to them, and they've gone through most of them. I'm just kind of reading out some of the ones that are interested, or right now I'd like to get a public understanding of. So I don't know if you have a chance to look at that section, but there seems to be a clear contradiction there. Under 7.3, it talks about a penalty stage, and it kind of jumps off from violation to conviction. But there wasn't any explanation of the process in the middle.
The process in the middle is going to circuit court.
Okay. I mean, that just seemed to make a big jump. There's some things in non-compliance that didn't seem, a notification, a process down the road. It just went from, here's a violation, here's conviction. So I thought that seemed to be missing something. Other than I had, on page 1, it talks, there's a reference to administrative, and then it talks about exempt. Is administrative and exempt interchangeable, or are we talking 2 different things?
Are you talking about the little
It's
chart?
on page 1, and it has this.
This is technically page 1.
Okay. Okay. Well, no, they are not interchangeable. Exempt is a class of subdivisions that simply be reviewed administratively and certified. All of those 5 or less, a minor change due to a resurvey, something like that. Now, because you can't, it may be minor like that, but you can't go directly to the clerk. You still have to come and have us certify that plat. But that's all administratively approved as opposed to going to the planning commission, and the planning commission have to vote to do that. That's the same way with the minor subdivisions. Those are administratively approved because the planning commission has delegated the authority to the staff to do that. So it does not have to go to the planning commission or have the public hearings or that sort of thing.
You answered my question regarding public planning commission composition, so I don't think I have anything
I have
else.
some more questions.
See that they are.
I know. I'll be very careful on this. We heard about the cost that would be associated with this. Let's go the opposite way. Let's say that the cost would not go to the developer. How much would it cost the county to provide the services that you're requiring, such as, and the type of people, engineer, individuals, costs, and how long would this process take? Someone's going to have to pay for this cost. Someone's going to have to, the county, how many more employees are we going to have? You have to have an engineer, correct? What's the cost for that, and how do we do that?
I provided that.
It's in your admin folder.
Well, I'd like a public place.
Okay. The difficult portion, and we discussed this at the work session.
That's
difficult
exactly.
portion is to determine how many of these we're actually going to have. The best we could do is go through the assessor's records and try and get a handle on how many. Now, part of the problem with that is the assessors are not keeping records of what we would define as major or minor under this ordinance. There's no reason that they would have that information. But we figured out the average number of splits, the average number of what we could determine as major new subdivisions and continuations of subdivisions by years. The bottom line is between 2010 and 2017, the average was 8.3 per year for major, and for continuations, 12.1. Now, some of those continuations would be exempt under our new ordinance. They would already be existing, they'd be underway, they would be grandfathered in. But it's clearly the case that at least some of those will be additional new phases that would fall on the ordinance. So, it's a weak guess at best, but my guess was that we'd have an average of about 10 a year, all right? So you got 10 major developments a year that would require the engineering work. In talking to the engineer, we're looking at somewhere in the neighborhood of $3,500 to $4,000 for them to do the plat review, the bond estimate, and to inspect to ensure that it's being properly developed. So,
But just a clarification, but that was based on where you didn't have to have now a plat with a deed, is that not correct? So now we have all these deed. No, I'm asking a question. I mean, and that's what the purpose, because what about the 3,700 deeds that may be needing plats that have to be reviewed? Because you've asked if it's going to be exempt or not, or if you asked, it could be a minor subdivision, it could be a major subdivision, but it has to come to you all to make a decision. Is that not correct?
yes, it comes to us, but the only one that requires engineering are the majors. The others do not require an engineer to review, to make an estimate on the bond amount, and to inspect that they're being done.
And that would be reviewed by who, just for clarification?
It will be either one of two ways. It'll either be an engineer that we contract with, or it will be with several engineers that we have on retainers that we can switch off, so that if engineer A actually is proposing the subdivision, he can't be reviewing it, or she can't be reviewing it herself. So we have another one, and we rotate those around. The first one is much more ideal. You got the same person or group of people you're dealing with, but.
Okay, one more question, and it's simple. but it actually is for Mr. Panico. And the reason why I asked if you could come forward and answer this question, you've heard how Mr. Wood has explained exemptions and 8A. Would you agree with his interpretation, or how would you explain, are there exemptions with 8A and the explanation? Since you've, if you go to the board, 'cause I want to get a clarification, because we've heard one side, I want to make sure I understand that you may
Right here
not.
on the front, the first page, it tells you about the minor subdivisions. And at the very bottom in that box, it says, create no new street or improvements. If you look in the definitions of improvements, everything's an improvement. A gravel road, a water line, a drain line, everything's an improvement. So essentially, anytime you could come in here under this ordinance, everything will go to a major. At least 98% of them, unless you're not doing nothing with the lot, unless the lot gets cut out and nothing's done. Then you're not. But under this, the way it is, they give it to you on the front end, and it's getting taken back away under the definition of any improvement will take away that exemption. Under 8A, this, in my opinion,
Okay, because it's only your opinion, but you're on the.
this thing far exceeds 8A. 8A is not a complex thing. When you read it, it's 3 pages. And it says or land development, not and land development. You could take these subdivision regulations, there's very needed subdivision regulations in this county for sewer, road, stormwater, water retention that we all know we need. We all agree we need. But this far exceeds 8A, in my opinion. If you look at 8A and read it for what it is and compare it to what we have, this is vast. This is vast.
Okay, could Rich respond? Yeah, so I'll allow Rich to respond to that.
So,
Yeah.
All right.
Thank you very much for that. How would you respond to that? Because this is what we are debating and discussing.
Okay. 8A, 5.2, requirements for a minor subdivision and land development. Point 2, will not require the development of new or the extension of existing off-track infrastructure. Now, you can go and change that in the legislature, but I can't produce a document that does not accept that under the definition for minor subdivision.
Okay.
That's simple as that.
Thanks. I wanted to clear that up.
Thank you. All right. I will take a motion now for adjournment. I would suggest that what we should do with this is to digest that which has gone on. I would also suggest that we have an additional work session for discussion as to before placing or not placing this subdivision regulation on the agenda.
Discussion to answer any additional questions that may come up.
Pardon?
A discussion to answer any additional questions that may come up.
Yes.
Okay, so you can't debate something that's.
No.
Okay.
Motion to adjourn?
Second? It's been properly moved and second to adjourn. All in favor? Aye. We are adjourned. Public hearing is now concluded. Thank you.